8:30 on a Wednesday, and we're here with lawyer Charlie O'Hara. Sounds like we do have one call on the line, but if you have a question for Charlie, give us a call now, 316-436-1212. Charlie, it sounds like we do have one phone call.
Okay.
You ready for it?
I'm ready. Let's go.
Okay, caller, go ahead. You're on the line with Charlie.
Yes, I was wanting to find out, can they charge you, if you're renting an apartment in the state of Kansas, can the landlord charge you for water if you are not hooked up to an individual meter?
Well, I don't know. I mean, that's going to be a little hard to know how much you're using and how much other people aren't using, so I think it'd be a little difficult. I suppose, as I've said, in any kind of a apartment situation or rental situation, it's kind of an agreement between the parties, and the parties agree what's fair under the circumstances. Obviously, the landlord can't take advantage of people and charge one person some outrageous thing or charge another person or charge everybody more than it really is. So it has to be something you're negotiated, and it has to be reasonable. It has to be reasonable under the circumstances. So when you say, can they do that, that's probably a different question than should they do that, and whether or not it should be a meeting of the minds between the two parties. I would say it should be a meeting of minds between the two parties. You got to negotiate that. Okay?
Thank you, Charlie. Sounds like we do have a second caller. Caller, go ahead.
Yes, we have a lease with a commercial building, and the owner retained a key, and they went in without our permission or prior approval. And this was before we were opening, and we're sitting up, and we noticed we had lots of merchandise, so we filed a theft report, and then we changed the locks. Now they have asked for another key, but we don't feel like we can trust them. What is the legality there for us?
Well, again, we're usually talking about what's agreed to by the parties in the lease. So you're going to have read the lease you have. But usually, any landlord will have the ability in an emergency or something that happens to go into the business or residence even and make repairs or do things they have to. For instance, if the person leasing the property is gone and there's a terrible storm or there's a leak there and something's leaking, the landlord has to be able to get in to fix that if they can't get a hold of the renter. So they have to have some access depending on the circumstances. If the landlord's stealing from inside the property, that's a real bad situation, and it may not even be a property you want to rent or anything like that. But I think you're going to have to look at the lease. You're going to have to determine what the lease says, and that should control under the circumstances. Okay?
Thank you, Charlie. It does sound like we have a third question. Caller, you're on the line with Charlie.
Yes, I was wondering if a person that had a non-violent felony drug conviction could ever own a weapon.
That's a very good question, and I think the answer to that is actually yes. I always have kind of a caveat with everybody that I represent anyway, because the problem is we have federal law and state law, and the state law has some circumstances after 5 years after you've quit being on probation and got over everything, or 10 years depending on the circumstances, or some circumstances never. The federal law says you can never have a firearm afterwards, but usually the federal law kind of gives to the state law. So you really need to check with an attorney specifically about that, and I would really check on that. But I think it is possible. It's something I don't always recommend because I'm always scared that the federal people may change the law, and then you're going to be stuck with a felony. So I would sure check with an attorney. Okay.
Thank you, Charlie. And we can believe it, it's a busy Wednesday. We have a fourth caller.
All right, well, good.
Got a little bit of extra time. Caller, go ahead.
Hi, Charlie. My name's Frank, and I would like to know, you know, they've been busting these gambling machines all over Wichita up and on we see, but yet there's places that have like 20 and 30 machines in them, and they're all paying out. Sometimes they give out free buffets, and they'll if you're sitting at a machine, they'll call out and give you $100 or $300. Are they going to still allow these machines all over town for the last 10 years?
Well, I don't know. I mean, now you're talking about a little bit of a politics. The fact that something is against the law doesn't mean people do it. I mean, I wouldn't even be in business. The jails wouldn't be full. We wouldn't have all the courts that are doing all the things in criminal cases. People do violate the law. If these machines are against the law, you shouldn't be using them. They shouldn't be in a restaurant. If you want them to be legal, we need to go to the legislature and change that. So if for whatever reason they're not being enforced in one restaurant or bar and being enforced in another restaurant or bar, that's kind of the luck of the draw. But the fact is that they're illegal and they remain illegal, and we need to change the laws if we want to have things legal.
Thank you, Charlie. We really appreciate your time.